Hi, my name is Diana Schwartz and I'm a Senior Associate at PPM Attorneys. Today I would like to talk to you about the ins and outs of court reporting for the media. In recent times it's been quite a controversial subject discussed on what journalists are actually allowed to do and what they're not allowed to do in terms of court reporting. So today I'm going to give you a brief guideline on what journos are actually allowed to do. The first thing I'd like to chat to you about is access to the courts. So the courts are generally open to the public and the media in both criminal and civil matters. This is in accordance with Section 16 of the Constitution, which is the right to freedom of expression. However, in certain circumstances, court proceedings can be closed to the media, especially in cases involving children and family-related matters. This occurs unless the presiding officer in the matter exercises their discretion as to whether to allow access to the public and the media. In criminal matters, courts have a discretion to close the courts and impose reporting restrictions in exceptional circumstances. This is very important and journalists must take note of this. These cases include during the testimony of witnesses who may suffer harm, when children testify, or in sexual extortion cases upon the complainant's requests. When complainants in sexual offences cases testify, there is an automatic disclosure and cases involving national security. In civil matters, courts are generally always open, however they may be closed also in exceptional circumstances. Such cases would be issues that involve national security or issues where very confidential or intimate information is involved in the case. Journos are protected in certain instances. If you are publishing fair and accurate reports of the court proceedings, these reportings are generally protected. Cases involving children are a very important consideration that journalists should take into account. The general rule is that of secrecy, with the discretion to allow access. Even if access is granted, the identity of the child may not be revealed. If a child, however, turns 18 during the criminal or civil proceedings, the media could ask the judicial officer if his or her identity may be revealed. What is very important to note is that no information that reveals the identity of the child may be published. In criminal matters, journalists should not reveal the identity of a child accused or a witness, subject to the presiding officer's discretion. In civil matters, no information that reveals the identity of the child may be published. Then we have cases involving domestic abuse. No information may be published that may reveal the identity of parties to the proceedings. This is in accordance with the Domestic Violence Act of 1998. Then we have cases involving harassment. The media or public may be excluded in appropriate cases in the interest of justice. Identification of the parties may also be protected upon the order of the court in terms of the Protection from Harassment Act of 2011. In divorce cases, the details of divorce proceedings may be published. However, the identification of the parties is not allowed. This is in accordance with the case of Johncom Media Investments Limited versus M and Others of 2009. So you may ask, when may the identity of an adult actually be published? There is no general rule that an adult who is suspected of being involved in criminal activity or is under arrest for involvement may not be identified or named before the first court appearance. However, no photographs may be published if a person is in custody pending an appearance. This is in terms of the SAPS Act of 1995. Now we come to a very interesting section of court reporting, tweeting and broadcasting from court. There is no prohibition on journalists tweeting from courts, but journalists should take care that their tweets are fair and accurate reflections of the court proceedings to ensure their protection under the Qualified Privilege Defense in Defamation Law. Our courts are more frequently allowing sound and video broadcasts for television and radio, such as in the Oscar Pistorius case. Journalists should be aware of being held in contempt of court. Journalists can and will be held in contempt of court for the following: failure to adhere to a court order, scandalizing the court, that is criticism of a judgment or a judge or the judiciary, which poses a real and substantial risk to the administration of justice, may not be published. Another very important rule that journalists need to be aware of is breach of the sub judice rule. This rule prohibits the publication of material that prejudices an ongoing or forthcoming civil or criminal trial. if a publication might cause demonstrable or substantial prejudice to the administration of justice, and there's a real risk that prejudice will occur if the publication takes place. For more good, clear, precise advice, please feel free to contact us.